All right, welcome everybody to the October ConMaciel Labor and Employment webinar. So today we're going to be talking about one of my favorite topics. I should introduce myself. I'm Aaron Galb, one of the partners at ConMaciel. I'm based in Chicago. I've been a management side OSHA and employment lawyer for just a little bit under 30 years now, as much as it pains me to say. And the ADA, and particularly the interactive process, is definitely one of my favorite topics to talk about, because I think there are a lot of ways that having a good program and training and knowing the kind of the ins and outs and some of the intricacies of this law, and particularly this obligation, can pay big dividends. So I'm particularly excited to be joined both by my partner in California, Megan Shaked, and Megan will introduce herself in a second, but also my friend here in Chicago, Diane Spason, who is the acting district director for the EEOC Chicago office. And Diane can give you, I'm sure, some of the stats, but I assume one of the busier and bigger district offices in the country, certainly one of the more active and trailblazing in a lot of areas. So really excited to have Diane join us and share the EEOC's perspective, which I think will be particularly valuable for our audience. So with that, Megan, I'll let you introduce yourself, then Diane, and then we'll just jump right into it.
Sure. Thanks, Aaron. Hi, everyone. I'm Megan Shaked. Like Aaron said, a partner out of our ConMaciel Cary's San Francisco office. I handle things out in California, and excited to chat with you all today about this really interesting topic. In California, we of course have our own kind of local scheme, but the ADA applies here just as well, and we're really excited to kind of get into the details with you all today.
Hi, good morning or good afternoon for those for whom that may be the case. I'm Diane Spason. I am with the EEOC. I've been with the EEOC for over 25 years, and I was in the legal unit. I'm a lawyer. I was in the legal unit for many, many years and litigated employment discrimination cases, including ADA cases. And a few years ago, I became the deputy director in the Chicago office, where I've been throughout my career, and I'm currently serving as the acting district director. And I'm very happy to be here. I enjoy talking to employer groups and representatives and talking about the ADA in particular, which is a very tricky, difficult statute. And Megan and Aaron and I talked about this in our prep. It is the most confusing and complicated one, certainly, that the EEOC enforces. And I think, especially for lawyers who work in the area, it can take years and years of practice and experience and learning the ins and outs of it. And there are still always things that stump us. So we feel your pain, and really at the OC, we do. We know this is hard stuff. These are hard cases. So I would say, don't go at it alone. You want to get some legal counsel, especially on something that's particularly tricky. Because there are so many complications, and the law is different in different circuits as well, especially on things like leave policies, which we're going to talk about as well. I think one main thing to think about that I would just offer as a little bit of general advice is to think outside the box when you're dealing with accommodations for people with disabilities. I think companies often get very rooted into, well, this is how we do things. This is the rule. This is how it's always been. This is the process. This is the procedure. And for dealing with accommodations for people with disabilities, you really need to think outside the box and think, well, does it have to be done this way? Maybe it doesn't. Maybe we could get the same results if we did it this way, and we could get this person in a better situation to do their job. So you need to stretch your mind, and you need to be open-minded and be open to suggestions that the employee will make. They know their limitations better than anyone. They often know other options within the workplace that might be available from talking to colleagues. So you want to engage with them, and we'll talk more about that. But But that's one of the first things I would just say is be open-minded, be open to different options, think outside the box. And the other thing is that this is a law that requires you considering giving someone a preference in a way. That's not the term that's used, but I think most employers are used to thinking we must treat everybody equally, based on race, sex, age. And that's generally true for the laws. But when it comes to the ADA, this law is a little different in that it says if someone has if someone has a disability, they may well be entitled to different treatment that helps them, that gives them levels the playing field. Because if they have a disability, they're playing beneath the playing field, and this makes them come up to be on par with everybody. And that is your job as an employer, to see what you can do to provide some kind of step up for them or assistance for them. And that's okay. And if other employees complain and say, well, why does this person get this or this? It's a private matter. I can't discuss it with you. It's a private personnel matter. You are not obligated to reveal that. As long as you know you're doing the right thing and you're providing an accommodation under the law, that's sufficient explanation generally. So you do need to think of it as, what can I do to help this person get back to work, even if it's giving them some assistance? That's the point of this.
Yeah, I think that's a important point I always try to make as well. I mean, the ADA has been really one of the few laws that has two components. It's got the non-discrimination component, just like Title VII, where you can't treat somebody differently or worse because of their race, sex, or the ADA. ADEA, you can't treat them differently because of their age. You similarly can't fire someone because they're disabled or they have a disability. But like you're saying, Diane, there's also that additional requirement to go above and beyond, and sometimes provide them with additional things. So and to engage in the interactive process. And the reason we titled this program the way we did is that the process itself, I mean, you hear that expression, that's tried a little bit of a play on words. I mean, there's that expression, trust the process. Right. I mean, football coaches use it and experts use it. I mean, the process exists for a reason. And that's the way I look at the interactive process, is that you may not always get it right, but if you go through the process, and part of that process is being open-minded, being willing to explore different options. And if you do those things, generally you're going to have a far better outcome than if you don't fully engage in the process. So our plan today is to first go over and help you understand both the expectations from the perspective of the EEOC, from the perspective under the ADA, the expectations and limitations of the reasonable accommodation obligation. We'll take a deep dive into the importance of good faith efforts to go through the interactive process. And then throughout, and our plan today is Diane is going to share her perspective and input on various topics throughout the program. And then she'll share some additional thoughts at the end. But our goal is to for all of you that are listening either live or subsequently to our recording, to really understand areas of emphasis and focus for the agency, the things that the agency is seeing, the things that they're concerned about, things that they like to see from employers when they're going through investigative files. So that's the plan. So I will turn it over to Megan to take us through the next series of slides, and then I'll come back and talk to you all again shortly.
Thanks, Erin. So we'll kind of dive right in, but before I do, I just want to, Erin mentioned the importance of kind of trusting and understanding the process and really going through that process. But one of the things that we also really want folks to keep in mind is, have those good instincts of when you might be in a situation that you have to, kind of start the process in the first place. So when are those moments when your, ADA instincts rise and you say, oh, wait a minute, this might be a time where I need to think through this, get legal involved, or, ask those questions about whether this needs to I need to start this interactive process or not. Is this something I even need to be thinking about? And so we'll kind of start with a little bit of context for this conversation, and then we'll keep getting into more details. So first off is, what is a disability under the ADA? It is an impairment that substantially limits one or more major life activities. And, that might be a little bit nebulous of a standard. What isn't a major life activity? But this is something that, from the very start, you want to think through about what are the things that would trigger an employer's obligation to reasonably accommodate an employee or not. And it's not just that somebody has what's considered under the ADA a disability. It could also be somebody being regarded as having an impairment. So you kind of have to think about it from both directions. If somebody, it's a little bit easier when it's a known disability, but if there is information coming across about known limitations, kind of those spidey senses should also be going up in those instances to consider whether the obligations are being triggered. Another thing to understand about the employer's obligation is that the employers must provide a reasonable accommodation to qualified individuals with disabilities, but it applies not only to employees, it also applies to applicants for employment. And the restriction is on providing the reasonable accommodation is unless it would cause an undue hardship. And we'll get into a little bit more detail about what it means to be an undue hardship. But initially, at least, knowing that the reasonable accommodation obligation applies to people who are applying for a position and as well as employees. And that's really important because if there are restrictions to the application process that somebody might need an accommodation for, that's something you need to think through and be open to. Things as simple as accessing an application, but also things that might be more complicated, like coming in for an interview. Obviously, they'd have to be able to access the work site and things like that. So making sure that you remember that it applies across the board like that.
Yeah, and just to kind of give one real world example, if someone has to take a test, an online test to evaluate, their, let's say, attention to details, which I see for certain positions like hotel housekeepers, it might be look at a room and find 5 things that appear to be out of order, and if there is sound that is part of that test, and the person is hard of hearing or has handicapped, has a hearing disability, you would very likely have to make an accommodation so they could take that test on a similar terms as someone who does not have those limitations. So that's an important point, but just wanted to give one real world example.
Another kind of category that we'll spend quite a bit of time talking about, and this is what Diane referenced in terms of being open-minded about what the actual accommodation is. The ADA and guidance provides quite a bit of information on kind of what are the types of things that employers can provide as an accommodation, and things you may be more familiar with and less familiar with, but just to give a sense of kind of the broad categories, we're talking about things like, Aaron just mentioned, adjustments to the job application process, modifications to the actual work environment, or some particularities of the job and how it is performed, and as well as an employee's ability to kind of enjoy the same benefits and privileges of employment as all of their coworkers. So really thinking through all of the details of how an employee or an applicant accesses the job, and then how they actually perform their job as compared to their coworkers, and thinking through what particular adjustments or modifications might be made to allow them to essentially perform the essential functions of the job. That is the goal through this process, is to make a determination about whether an employee can perform the essential functions of the job with or without accommodations. And then ultimately, you know, whether those accommodations rise to the level of an undue hardship or not. And if they don't, then, you know, is there a way for the employer to accommodate them? So getting kind of a layer more detailed into the types of accommodations that might be required, it could be things like, you know, adding a ramp so that somebody can access their office space, or making adjustments to their particular cubicle so that they can, you know, have access to the tools and the equipment that they need to do their job. It might be restructuring the job in some way that allows them to perform the job. It might mean changes to the actual work schedule, or like I said, the equipment or the materials that they're using. The category of, you know, kind of changing test or training materials or policies, you know, that could be something like, you know, if it's a timed test, allowing additional time for somebody to perform the test, or adjusting the way that the person is given the information in order to test their abilities to perform the job. There could also be, and we'll get into a little bit more detail, hopefully with Diane chiming in on some of her insights on this. There could be accommodations could take the form of perhaps a leave of absence, but also a really area that's fraught for employers sometimes is reassignment to an alternative position. And kind of we'll talk through thinking through that possibility as a type of accommodation. Now, the obligation for an employer to accommodate an employee is not without limitation. So the accommodation only has to be to an employee's physical or mental limitations. The accommodation needs to allow the employee to perform their job. So the accommodation does not need to be beyond that. The employer is obligated to provide a reasonable accommodation. So there isn't an obligation. While you would ideally have a back and forth conversation with the employee as part of the interactive process, there could be a situation where an employee, you know, requests a certain reasonable accommodation and the employer suggests a different reasonable accommodation. The obligation at the end of the day, excuse me, is for the employer to provide a reasonable accommodation. So that's really the discussion and the end point that we're trying to get to.
And may I just jump in on that a second?
Please.
Yeah, and so you're right in that it is a reasonable accommodation. You don't initially necessarily need to provide many, but you may over time need to provide more than one. And you need to keep in mind that while you as the employer may think this is reasonable, the employee may not. And that doesn't mean you were there right or wrong necessarily, but you need to listen to what they're saying about why maybe the accommodation you've proposed isn't going to work for them and isn't reasonable. If that makes sense, if there's some, you know, credibility in that, then you do need to come up with, or I would highly suggest you try to come up with another accommodation if there is such a thing. But so do keep in mind that you may need to, as I said from the beginning, think outside the box and think of more than one possibility.
Yeah, I think that's obviously, yeah, very, very, very good advice. And I think the issue that we see sometimes on our side is more so that an employee may have a specific thing. This is the only thing that this is the one thing I want, right? And thinking of it, you know, that there's more than one way to you know, I don't want to say skin a cat in case there are any cat lovers out there, but whatever, you know, that expression, right? That there may be 2 or 3 ways to get to the same result, whether it's, you know, one device versus different advice. One way to get the person, if the person is hard of hearing or has vision issues, different ways that they can read things, different ways that they could get information shared with them. But to Diane's point, I mean, you don't want to be so resolute that you refuse to consider something that the employee provides, but if it gets down to, and you feel comfortable that you fully explored the options and what you are offering is indeed reasonable, right? Then you're going to be in a far better position, in my view, and just understand that I think some employers get a little caught up, like, well, this is what the employee wants, and obviously you should be listening to the employee and taking feedback from the employee. Obviously, if you give them if you can give them the accommodation that they ask for, obviously that tends to be an easier approach, because you're less likely to file a charge or file a lawsuit if they don't get what they want. But if you find yourselves at loggerheads where it's really like the person is being in your view being unreasonable and only willing to accept something, I mean, sometimes you may end up like, well, this is what we believe is reasonable. So not suggesting that you obviously reject or deny the accommodation that's requested simply because you think you have one better. But in situations where you've gone back and forth, if you feel comfortable that you come up with something reasonable, you don't have to give the person exactly what they want. But you're going to want to have experts or vocational experts or technical experts who would tell you, yes, this is reasonable, before I think typically before you reject something. So that just kind of my perspective on that issue. So.
Yep, continuing down the list, I mean, all of these kind of the limitations on the duty to accommodate is something to, give a lot of thought to, ideally with counsel involved, to kind of understand the real practical meaning of the limitations. But the just finishing off the list, the duty to accommodate does not require creating a new position, and it does not require removing essential functions from the person's position. Of course, that last bullet is also fraught for disputes over whether a particular part of the position is indeed an essential function of the job or not, particularly in situations where it may technically be part of the job, but perhaps that employee hadn't been performing that part of the job. So there might be disputes over that.
Yeah, and sorry to keep jumping in, but one example of a case that I always thought was very interesting was someone who was in a managerial position at a food service company. And part of their job, and Diane will tell you, I mean, it was in the job description. It was, that something that was documented as actually part of their responsibility was to occasionally make deliveries. So even though they were a manager, if several people called off or there was some emergency kind of hot run that needed to be made with some product at the last minute, that manager would be the one driving the truck. And so they might only do that once a month or even less frequently. But when this person had a disability that rendered them unable to drive, that meant that they could not perform one of the essential functions of their position. So the frequency or regularity of a task doesn't necessarily determine its being essential. So it's just one of those issues you really have to look at each case on a case-by-case basis and not assume something is essential when it may not actually be essential, or vice versa, that even though it's not commonly done, it may well be essential.
When we talk about undue hardship, so remind everybody the obligation for employers is to provide the reasonable accommodation unless it presents an undue hardship. That's really a term of art that needs to be very well kind of understood and evaluated. And it's not enough for an employer to just say, oh yes, what the employee is asking for would be an undue hardship, end of evaluation, moving on, right? You have to really so the question is, does the action require significant difficulty or expense? But then the employers really have to dive deep into that and look at all of the factors that need to be considered in making that determination. So things like, the financial resources of the employer, the nature of the operations, what the impact would be of that accommodation on the business. And again, it's not just enough to make assumptions or speculate about what that might look like. This might entail doing a real assessment or getting experts involved or getting information from potential vendors that you might use to bring in alternative equipment or change construction in a given area of the workplace or things like that really need to employers need to kind of think through all of the details. And obviously this is going to be very fact specific depending on the request that's being made and the particularities of the interactive process. And to Diane's point about, this might change over time. So you might have to do this assessment more than once, depending on how involved the interactive process is and what the employee might be asking for. So this, and I would love Erin or Diane to jump in on this to give us kind of some practical insights into how this undue hardship piece plays out. Is this something that is, it's there in the law, it's part of it, but how much is this actually being part of the conversation and part of the analysis at the end of the day? Or is it a situation where a lot of the things that employees are asking for really don't rise to the level of creating an undue hardship for employers?
Yeah, I was going to say I don't raise that argument very often, if at all. I think maybe operationally more so than economically, but I was going to just ask Diane to share on her end how often she sees it and how often it's actually valid and how the EU is.
So this is a tricky area as well. And I think Erin is right that I think to try to argue financially that it's an undue hardship is going to be harder, especially if you work for a large organization that is relatively well off financially. You're going to be hard pressed and you're going to have very specifics. Like, we looked into this and this is exactly how much it'll cost, or approximately how much it'll cost to, let's say, hire another person or to farm out this area or or this duty or something like that. It's going to have to look really onerous. I think operationally making changes is an easier argument to claim it's an undue hardship based on what it is. But the thing I see a fair amount is where we get people who are filing a charge of discrimination and they ask for an accommodation, they didn't get it, and they say, but I know that they let so-and-so do such and such, which is similar to what this person is asking for. So it's like they know the ins and outs of their colleagues and what everyone is sort of allowed to do and not do. And you need to inquire about that and find out, like, is everybody really doing this job or does someone help someone with it? In which case we need to consider for this person providing that same kind of assistance. Sometimes that stuff is done like under the radar and isn't done as a formal reasonable accommodation, but people are helping each other out. And you might find that somebody's sort of been getting an informal accommodation for years that's similar to what someone's asking for, and your initial response may be, oh no, we can't do it. Well, maybe you actually are doing it, you just didn't even know that, and it's being done on a more informal basis. So you really need to ask questions and press and do push back at that last point when operations tells you it's unreasonable. Like, they're going to tell you that no matter what, probably. I think you have to go in with that assumption because they are used to their operations running the way they've always operated. They're not used to thinking outside the box. And it's your job to force them to think outside the box or to think outside the box for them once you get the underlying information.
Yeah, and as someone who has litigated cases and gone through electronic discovery, I can also tell you, you better ask them, like, what, what have you put in emails? Because I've seen too many cases where, the manager just clearly, this is going to be a problem and it's a headache for them. It's the last thing that they want to do is deal with someone who's going to require that more work than just a non-disabled employee. And I've seen some pretty troubling emails, not frequently, but over the course of the years of litigating these type of cases, and I think recognizing that managers are going to generally their initial reaction, maybe I can't do that, and they may even put something in emails to that effect. So you just have to be kind of careful and make sure people understand what the obligations are of the company and themselves. So.
Right. So I think we have a couple more slides on undue hardship, but it's really to cover kind of the things that we've talked about, like what does this mean in terms of financial impact, and then thinking through the operational impact of the request and anything else that needs to be considered as part of that. It's really as part of the, evaluating the request that's being made.
Yeah, I think this slide, Diane, I typically give this presentation without someone from the EEOC involved. If this, I'd be interested in your perspective. Is my understanding has always been the EEOC considers the net cost, meaning if there are tax credits available from a government, if there are
Yes,
so grants, governmental services, translation services,
yes.
so I don't know.
That's very true. We do, and you should too. You should again think outside the box. Like, are there some some government funding that could help us provide this kind of accommodation? Because those things do exist. And yes, it is going to be more work. Yes, it's going to take some time. It's going to take some effort, and you have to have somebody who's going to do it. But you may, under the law, need to do that. One of I would highly recommend, and when in prepping for this, Megan and Aaron both were familiar with, and I want to make sure you all are, an organization called the Job Accommodation Network, JAN, Jan. I'm sure if you look them up on the internet, you should find them soon. They are a disability rights organization. They provide lots of assistance in terms of ideas, creative ideas, information, resources, all for free, that an employer can reach out to and get information from them about how might you suggest I go about accommodating somebody with this disability and under this circumstance. So if you can show that you've made those efforts, you've reached out to some of these resources that are listed here and like Jan, to try to see if you can make this work, that will go an enormously long way in showing that you've made the effort and prevent liability. Because frankly, most employers don't, or a lot don't, I should say. And the more complicated the request is, the less likely the employer is to make that effort.
Yeah, the Job Accommodation Network, as I understand it, it's been a couple of years since I've had a client that's worked with them. But my understanding is that they will provide kind of generic feedback if you want to remain anonymous. But they have, I believe, specialists, and even on their website there are people who are familiar with or expert with different conditions, different types of different disabilities. They have specific, I think, advice for certain types of disabilities. But I believe you can if you are willing to disclose who you are, they will even provide kind of a specific opinion. And that's probably pretty rare that folks are willing to do that. But if you're really committed to going through that process and again being creative, you might say, you know what, this is who we are and this is the issue, and we would like your experts to opine on this. And they may tell you, either give you a suggested accommodation, or they may say you've done everything that you can conceivably do and we don't see anything else. You'd want to really be mindful, I think, before you go, obviously disclose yourself and your organization, but it is something to consider. And even if you don't go that far, I think it is a great resource. And if you could just show that you've consulted them, or you've used their website, or you've spoken to someone there, and you've then taken that information, gone back to the employee and shared that information. So it's like, no, we weren't just willy-nilly coming up with ideas, out of thin air to present to the employee. We actually consulted with the Job Accommodation Network, and that's why we proposed this.
I think we can probably move on to the next slide, unless there's anything on this one, Erin, that you wanted to address. I
think I'll just briefly address. I mean, this is pulled, partially pulled from one case where an employer did prevail on the undue hardship argument. I believe it was either a bank or a financial services company, and the position that they needed to fill involved like access to highly confidential, personal financial information. It required certain skills and training and extensive training that would take weeks, if not months, to get that person up to speed. So very different analysis of either an extended leave or filling the position with a temporary employee for that type of role versus someone who works on an assembly line in a entry level position. It's going to be a lot harder for that employer to argue like, oh, we couldn't find someone to temporarily fill in while this person finished their leave, versus this is a highly specialized position, and if we can't start filling it permanently, we're going to be disadvantaged. So I thought that was an interesting case, and you really have to kind of look at your inability, who else can perform the work. Are others being required to take on additional work now that they're all overloaded and they're not doing their work? But you really need to demonstrate and document that you've done that analysis, and again, not operate on assumptions or beliefs as opposed to an actual analysis.
Right. So taking just a step back briefly, we want to make sure that, the goal is obviously to be conducting this interactive process correctly and adequately, but how do you, what triggers starting that process? And there's no magic words that an employee or an applicant needs, or even a representative of an employee needs to use in order to kind of trigger that process. So it might not always be the case that somebody, shows up to work with perhaps a doctor's note with restrictions and says, I need a reasonable accommodation under the ADA. It might look very different. It might be a clear request, but it might come in a context that doesn't immediately shout out to you that this is a reasonable accommodation request under the ADA, right? Perhaps it's somebody just asking for help, just in general. I'm struggling with this, that, or the other thing. Or perhaps it's somebody who has been performing really well, and then all of a sudden something changes. Their performance is lagging, or their attendance has changed in an unexpected way, or they something else is going on that is not consistent with how they've been performing in the past. It could also happen many different times in the employment cycle, right? It could come during the application process. It could come at the beginning of somebody's employment, or it could come when they've been there for, years and years. We often also see this coming up either during or towards the end of a leave of absence. And that is really an area that can be very tricky for employers, and where things oftentimes go sideways is when employers perhaps forget that even if an employee is at the tail end of their protected leave, maybe they've run out their FMLA leave, or they've run out their allotment of leave under employer policy, but there still might be an obligation to consider a reasonable accommodation under the ADA. So you can't forget that part. No formal request. It doesn't have to be, you have to use a certain form or you have to give it to a certain person. So you want to make sure that your team is properly trained so that if something comes in that might, be a trigger for this, that it's elevated to the proper people who really have the ability to handle the request and take it from there. And, we also do see situations where, perhaps the obligation is based on, employer knowledge of the disability, but maybe that knowledge is kind of not clear at first. So maybe there's some information, somebody had an absence, but you don't know why. Somebody has a performance issue, and you suspect that something might be going on, but you don't know why. And you don't know all of the details. It might entail some questions by the employer to get at that information. And maybe, it's not something so direct that says, do you need a reasonable accommodation under the ADA? We've noticed X, Y, and Z, but maybe it triggers a check-in with the employee just to see, hey, we've noticed that you have, had some changes in your performance. We wanted to see if you needed assistance or you needed to touch base about something. And if it's nothing, then that doesn't trigger an obligation. But if something comes out that the employee, well, actually, I have been wanting to ask if, X, Y, Z, then you have that confirmation and kind of what to do from there.
All right, Diane, anything to add regarding?
No, yeah, I think Megan really hit it all. I was going to stress they don't have to use certain buzzwords. They don't have to use disability or reasonable accommodation. They can say things like, I'm having a hard time with this, or I'm not able to do that. And it could, as she stressed, just be based on your observation too. So keep that in mind. You may have an obligation to be proactive about asking an employee what's going on and if they need some assistance, if it's obvious, if it's visible, if you're put on notice in some way that they're struggling and having difficulty, even if they don't come to you. And sometimes employers think, well, they didn't come to me, I'm not going to, open that Pandora's box or something. But you might have an obligation if it's really obvious and like the workplace knows this person is struggling. And maybe, in fact, they're not coming to you because that's part of their disability and they have a hard time for whatever reason, emotionally, intellectually, to express those concerns.
Yeah, and I think I look at at the end of the day, it's tough to thread that needle. I think because as employers, we have to be careful not to make statements that suggest we regard the person as disabled. At the same time, I think the way you put it is good, though. It's in terms of, obviously, if someone walks with a cane, they have a wheelchair, they have other outward signs of being disabled, then I don't think we're, no one is suggesting we regard them as disabled if we ask them if they need help. What I recommend that employers do, if it's more of a gray area, maybe the person has made comments that suggest they have a disability, but they've never come out and said it. Maybe there's one of my favorite phrases, there's water cooler talk, like a lower level manager says, oh, I heard this person has this disability. If there's enough out there to suggest that they might, but you're not sure, the way I always recommend that employers approach it is just by asking, hey, we've noticed this, your performance, or you're struggling with this aspect of your job. Is there anything that we can do to help you perform your job? Perform the essential functions of your job, and you put the ball back in their court. If they say no, then I feel the employer has discharged its obligations. And if they say yes, and even if they don't say I have a disability, but they say, yes, I need this, and this, maybe that's something you would do for any employee. So you go ahead and do it. Maybe it's not, in which case you say, okay, we need to understand if you're asking for this modification to your job, why do you need it? And at some point, maybe you're going to actually give them one of my favorite tools, the reasonable accommodation request form. So they put in their, they are committing in writing to what it is that they need. It's one way to help kind of eliminate misunderstandings or confusion. And I think Diane raised another important point about maybe they have some intellectual or some other reason why they are challenged or incapable of fully explaining what they need. And so in the first bullet point, the word lawyer is there. If somebody says, I'd like you to talk to my lawyer about my needs for an accommodation, I think a lot of employers are going to reflexively reject that. Just as they would reject a lawyer participating in a performance review or a suspension meeting. And I will tell, 99 times out of 100, I'll tell my clients, you are absolutely well within your rights to refuse to have a lawyer participate in a disciplinary meeting. But I would think outside the box, like Diane's suggesting, if it's an accommodation meeting. Because this is again that you're going above. It's not the same thing as the other employment laws. And if that lawyer is whether it's a family friend, which I've seen happen, or someone who has represented that person in a Social Security disability appeal, if they have unique information or are better able to communicate the needs of that person, why wouldn't you talk to them, right? That person is not necessarily representing them in a legal claim. They're trying to help them get an accommodation. Now, at some point, you may decide you would also could be well within your rights to say, we listened to your lawyer and we appreciate the information that he or she shared. But now if it's turning into advocacy or legal advocacy and not clarifying the accommodation needs, maybe you do discontinue dealing with the lawyer. There are people who work with coaches, with various organizations that work with disabled people that may be advocates that you might need to talk to. So again, kind of keep an open mind, I think is a big part of the theme here. All right, so I think it's a good transition. Without kind of getting too nitty gritty into the litigation side of things, I always talk about this part, this section of the U.S. Code, because I think there are a lot of people, including lawyers, that aren't familiar with it. And there's this section of the code. It's 42 U.S.C. 1981A. So not 1981 itself, which is the civil rights law, but 1981A, which is the damages provision. And then under that, section A3, which talks about, essentially, I won't read the whole slide because you've got it there and you'll get a copy of the slides. But the upshot is that if an employer can establish that it engaged in good faith efforts, and it's important that the section highlighted, in consultation with the person with a disability, that's the interactive process. If you could show you made a good faith effort to engage in the interactive process, what this section of the code says essentially is that even if you make the wrong decision, meaning you offer one accommodation that is not the right one, or you conclude that you can't accommodate the person, but you fully and in good faith engaged in the interactive process, ideally you've documented that. This is an affirmative defense that you can plead in litigation, meaning it's the employer's burden to prove. But if you prove it, you could theoretically go to trial, lose on the question of whether the accommodation was reasonable or not, and the person bringing the claim would not be entitled to any monetary damages. They would only be entitled to the accommodation. And obviously, throughout our overarching objective here is to avoid litigation, to come up with the accommodation. But if you need another reason to kind of sell it, is if you go through the interactive process in good faith, and you can put that evidence forward in litigation, it makes the case a lot less attractive to plaintiffs' lawyers. I certainly think if you have a very, very well documented and comprehensive effort to engage in the interactive process, the EEOC is going to be happier, far less likely to issue a probable cause finding. So just another reason to really engage in the interactive process. And if you have litigation, make sure your lawyer knows about this defense and that they are pleading it. I've seen a lot of lawyers that don't plead this defense to ADA cases. So and again, and Diane, please jump in. This is my perspective on the ADA. I always, my understanding from is that the EEOC and really the ADA, the preference is that when you're looking at possible accommodations, it's preferred obviously that the person remain on the job, in the job that they currently hold. So as Megan talked about the different types of accommodations that would enable that to happen, you might have to acquire equipment or assistive devices for them. Maybe you restructure some aspects of the job. Again, you're not eliminating essential functions, but there may be secondary or tertiary functions, or different location for the job, etc. So that's what you first should exhaust. Is there a way that we can accommodate this person so they're still doing the job that they hold currently? If that is not possible at this time, then the next question is there a leave of absence for some period of time that we could give to them, so at the end of that leave they will be able to return to their job? So that could be, except you're permitting them to use accrued paid leave or unpaid leave. You're giving them additional leave beyond what they're entitled to. Make sure, and we'll talk probably a little bit more about this shortly, that you are not just terminating people as soon as their FMLA leave expires simply because they've run out of leave. I'm even reluctant to mention some employers have capped leave policies or maximum leave policies. I know that to be very careful if you have those about how you administer them. Certainly there are, and here in the Seventh Circuit, the court, I think, has been pretty clear about what is a reasonable amount of leave. And I feel it's safe to say, if someone says, I cannot do this job for the next 6 months, the courts here at least are going to say, yeah, that's not reasonable. But that's pretty rare that we make decisions based on kind of maximum or cap leaves. So if you've explored the effort, you can't keep them in their current job. There's not a relatively short or fixed duration of leave that will enable them to return to their job. Then the last resort would be to evaluate reassignment to a vacant position within your organization. We've got several slides at the end where we'll dig into that, but that is kind of how I generally approach the hierarchies of what accommodations to explore in which area. So,
may I just jump in on that for a second, Aaron? And that is the issue of leave, which is a very tricky one. I would just caution you to be careful that you are not putting someone on leave and keeping them on leave as an alternative to a reasonable accommodation that you could be doing to get them back to work. We see this a lot, where employers think, well, if we just give them as much leave as they want, and they don't give them a maximum, but they just kind of keep them on leave, but forced leave is what it really may be, until they no longer have restrictions or until they're 100% healed. These phrases that we hear a fair amount about. You have to be really careful of that. And employers often say, but we were accommodating them. We were being so generous. We were letting them take leave and told them they could come back and touch base when they were better. That's not necessarily a reasonable accommodation unless the person and their medical professional says this is what they need. They need to be out on leave. But to force them out on leave to avoid doing another accommodation that would allow them to do the job is very problematic, and we see it a fair amount.
Yeah, that's a good point. And that's why I think that's what you should always focus on first. Is there a way that we could get them back here? But that's important, I think, perspective to keep in mind, that there are maybe because we work closely with our clients that we make sure they don't do that. But I think I can imagine that there are some folks that just think, yeah, it's easier to put them out on leave, but if they're not getting paid, then obviously that is not going to be an ideal. If it's unpaid or reduced paid leave, that's obviously not.
Exactly.
So one of the things, and the next several slides are kind of taking it step by step of breaking down how to go about responding to requests for accommodation. Just stepping back for a second, I strongly recommend that employers adopt a documented SOP or manual or process, written process to guide them. Not something that's necessary. You should have a reasonable accommodation policy in your handbook. But what I'm talking about is not something that's necessary of employee facing document, but more that of an SOP or manual for your HR team or whoever is responsible for managing the interactive process or the accommodation process. So you have some consistency, right? Whether that's that we are going to get back to people within a certain amount of time, that we're going to use this form, that, you know, when we get to this point, we're going to do this thing, just so there's consistency within the organization. So if you have a new HR person and perhaps not a ton of oversight in the department, that new HR person knows what to do just as well as someone who's been in HR for 10 to 15 years. Having that process, I know the EEOC has an internal protocol that it follows that's documented, and I recommend that you do the same so you have that consistency. So when you get a request, obviously evaluate it, make sure you understand it, right? This is part of that dialogue with the employee. Do you understand exactly what they're asking for? Have that discussion with them, get clarification if you need it. Same things I tell people before when they're preparing for a deposition, right? Understand the question, understand the request, ask questions to clarify it. If you know, ask the employee, maybe, you know, see if they're willing to, if they're okay with you either dialoguing directly with their physician. More often than not, that you have, typically what I recommend is that you give the employee questions, ask them to share those with their doctor. Ideally, perhaps you may give them a copy of the job description, have them give that to their doctor as well. And then the doctor usually will respond in writing and to those questions to help clarify any issues. The last bullet point just kind of addresses what Diane's already talked about. You know, that's a reference to resources like the Job Accommodation Network. You know, other sources that may help you better understand the issues that you're facing.
One thought about that last, the second to last slide or point, I'm sorry, the second to last point on the slide, Aaron, is about asking the doctor. We also see very frequently where doctor's notes say, you know, this person can only do this, or whatever. If you have any questions, please contact me. We see that a lot. Most doctors will write that. And yet we see so many circumstances where employers do not contact the doctors and their response is like, well, we didn't get enough information. We didn't really understand what they meant. We asked maybe the employee to go back and get clarification and they just didn't, or what we got didn't make sense. Okay, well, then the employer needs to take the affirmative step of reaching out and trying to communicate with the doctor in the doctor's office. I know that isn't always very easy. They have limited hours, they're seeing people, you talk to the secretary, you know, it's hard, but you've got to make that effort and you've got to try to do that. And that's often where employers fall down on the job when, you know, in a deposition, we say, well, so did you follow up with the doctor? The doctor said, please contact me for more information. Did you do that? No. Why not? Well, you know, I asked the employee to get something. I didn't think I'd get much more. You know, just these answers that don't really suffice. So be proactive, get that additional information. At least if the doctor isn't responsive or what they're giving you isn't helpful, you can say that you've tried and you weren't able to get far.
Yeah, I would let the employee know, right? Send the employee either a certified letter,
Yes,
email.
correct.
So we've made multiple efforts to reach out to your doctor and they're not responding. You know, we are going to have to make a determination on this question or this issue, you know, and we're going to have to go with the information that we've got unless we hear back from you or your doctor, right?
Right. And of course, you're probably going to need to get some sort of, you know, waiver from the employee that you can communicate with the doctor. But if you're trying to do something to help them work and keep, you know, in their best interest, presumably that's not going to be a problem.
Yeah. Right. So then kind of moving on, we kind of covered a lot of these bullet points. So I'll move quickly through this slide, but so you've gotten the request, you understand it, right? You've clarified questions that you have. Now this is where the ball's in your court as the employer to determine, can you provide the request accommodation? If not, is there another one that's reasonable? You again, Diane said, be creative, be open to new ideas, approach each request on a case-by-case basis, meaning you may have accommodated 5 deaf employees over the years who all needed the same accommodation, but the 6th one may be different. And what worked for the first 5, just because they all are deaf or hard of hearing, doesn't mean that that's the only option, or that's the only thing that you're required to do. So every disabled employee is different, and needs to be treated differently, or at least open to different accommodations based on the specific facts of that situation. Again, I can't say it enough. The process is interactive. Keep sharing information. Before you shut the process down and can reach a conclusion, go back to that employees or anything else, any other information, any other accommodations, anyone else we can talk to. I always say leave no stone unturned, and then keep going until you are 100% satisfied that we've done all that we can, or you've identified an accommodation that works for that individual. Again, I think kind of summarizing here, explore if you cannot, you've now fully exhausted what Diane talked about. You didn't jump to leave as the immediate option. You tried to accommodate them in their job. For some reason, you can't look at leave. There may be whether do they need block leave, like for a period of time, or is there some intermittent amount of time that they can leave on an intermittent basis that they can take? So we're not talking about FMLA, right? We're talking about now maybe they've exhausted their FMLA leave, and it may be that they were receiving leave on an intermittent basis under the FMLA, and you may need to continue that if that is a reasonable accommodation. Diane talked about this. Do not ever insist that the person be 100% healed before coming back to work. Be very careful. I've had clients that have said things to employees that sound like that. That's not what was intended. They may say you can't be restricted in your job, but what they really meant was you need to be able to perform the essential functions of your job. And that's what you need to be clear about. Like, these are the essential functions. This is what you need to be able to do with or without accommodation. So the ADA doesn't require you to eliminate an essential function, but you very well may have to provide an accommodation that enables the person to perform the essential function. So just be very mindful. If you have a policy, if you have documentation in your HR manual that talks about, because many employers years ago used to have these 100% healed or no restriction policies, eliminate those. Review, if you haven't reviewed your handbook or your ADA policy in a while, do that. Make sure it's clear that that's not a requirement. We know some folks use third-party administrators to manage the FMLA process. They may not be fully up to speed. They may simply say this person is unable to return. You can terminate their employment, but you have to have a discussion with them when their FMLA leave expires, if they're unable to return, to find out how much, is there an accommodation that would enable you to return? Or is there a brief period of leave for a definite amount of time after which you'll be able to return? So those are all questions that you need to look at. Your obligations may vary depending on which circuit you're in. The 7th Circuit leave is different here. I think it's a little bit more pro-employer as far as what amount of leave is unreasonable than other circuits. So make sure you're familiar with the law of your circuit when you're evaluating questions like that. I'll move quickly through these slides, as we talked a lot about leave. Again, I said it on the last slide, block leave. So that's just, you're off work, can be an accommodation. If the employee's healthcare provider is saying they are giving an estimated return date, that is not per se unreasonable. However, the more times that happens, if they keep kicking the can down the road and keep estimating, or say there's no way to tell when this person is going to be able to come back, that's a lot different than, I'm estimating 4 to 6 weeks. I have no idea when the person's going to come back. It could be six weeks or 6 months. That's very different. So sometimes there is that kind of death by 1,000 cuts where the person keeps asking for a little bit more and a little bit more. But if they have it, if they've just been off on a leave for a period of time and they say, I need another 2 to 4 weeks, I would not rush to either reassign or terminate. This hypothetical here that is set forth on the screen, this comes from a real case. The employer, the position was vacant for 3 months before the person was hired. The employer didn't do much to explore accommodations, and then when a person asked for a brief additional leave, they terminated them. It turned out that other employees were able to step in and do the work for them, and it took them another 6 months to fill that position. Well, how are you going to argue that it was an undue hardship to give them another 2 to 4 weeks if you didn't fill the position for 6 months? So it's kind of be frank assessment of the position and that you're going to take if you're going to terminate the employee or end that interactive process. Similarly, intermittent leave may well be an accommodation. I think it can, depending on the nature of the job, be easier for an employer to establish that it is unreasonable for a number of reasons. But you should be asking questions if that's the position you're going to take. Is regular or reliable attendance an essential function? Can the person do the job outside of business hours? If you're going to say like, no, we can't give you intermittent time off, but the person can work, from 9 p.m. to 1 in the morning and still get the work done when it needs to be done, then it's going to be harder to say that intermittent leave is not reasonable. Certainly, I mean, I've been using this slide since before the pandemic. Obviously, far more people are working remotely now. So, do they really need to be in the office at a specific time? If they can work remotely using or other forms of technology that enable them to quote be present and do the work. That's not to say that in-person work can't be required, or you need to just be more mindful of different ways that the work can be done. Again, leave as an undue hardship. We talked about this a little bit before, but again, you're looking at the impact on coworkers, the impact on operations. If someone's leave is it predictable? Is in terms of how frequently are they going to take it, right? If the doctor's note says that they might miss work 3 days a week, that's different than 1 day a week, right? And might make one is going to be more reasonable than the other. The predictability piece, if someone says I need leave once a week for my dialysis, and I always go on this day, generally in the mornings, it's much more likely that you can accommodate that than someone who might have a seizure disorder who says, I no idea when I'm going to experience an episode, and I might miss work, at any time and on any day. Again, but maybe the work can be accommodated with their position, but it's more likely that that's going to be unreasonable versus someone who has need for a fixed leave at a certain time each day or each week. All right, I think so. So now we're at the point we've determined we can't keep the person in. There's no accommodation that will enable them to do their job. Leave is not going to be reasonable for whatever reason. So now we're talking about reassignment. And in my experience, this is usually the step where I think employers have the most difficulty. My recommendations and the EEOC, and maybe Diane can talk about this in a second. I had, I think, a very interesting case. We won't talk about the name of the employer, but I think entered into a consent decree where this employer agreed to adopt like a documented step-by-step process for managing reassignments. Even if you don't do that, you should look at what are the available jobs that you have within your organization, not just at the same location where the person worked. Then just sit down with them and talk to them about what positions are they interested in. What are their qualifications? They may have qualifications you don't know about. Don't make assumptions. Don't assume that they're not interested in other jobs or not qualified for other jobs. Don't assume that they don't want to work at other locations. Here's one hypothetical. So someone is a server in an upscale kind of steakhouse restaurant in a hotel. Their restrictions prevent them from doing that job. But what if there's a coffee shop in the lobby that they could work in? But because they work as a server in an upscale restaurant, you only considered, in your other upscale, maybe they have 2 restaurants in the hotel, right? Well, we didn't have any openings at the upscale Italian restaurant, so we terminated their employment. But you never asked them, well, would you like to be a barista? Maybe they could have done that. So don't make assumptions about the jobs or the qualifications that person may hold. So I don't know, Diane, if you want to talk a little bit about that.
Yeah. Let me just say that on the reassignment piece, I think an area related to that where employers often fall down on the job is that, pun intended, I guess, is that they think, well, how can I just put this person in this position when there are other people who might want the position? And aren't they going to be upset? And don't they have the right to, compete for it? And the answer to that is maybe not. They may not have the right. Like, there again, going back to like, this is a preference statute. And if there is a job the person can do as an accommodation, and it would sort of get them back to work and kind of solve the issue, even if other people could be interested in that job, they can get a preference for it and do. The law says they don't necessarily have to like just apply and be considered and selected as the best candidate. They don't have to necessarily if they can do the job and it would be considered a reasonable accommodation. So I think employers need to think more broadly about that as an option.
Yeah, I think that's very, very good advice. And so what I, as far as best practices with reassignment, I think it's great if you have, like, if you begin the process with written notice, some sort of document that you could share with the employee, let them know that this is where we are in the process, how it works. Then, like I said, sit down, talk to them about their background, their skills, their abilities. You may have someone who has a degree that you don't know about, or has skills from a prior job that you don't know about. Talk to them about their preferences as far as shifts, locations. If you have multiple locations, don't assume that they don't. They work at one that's 5 miles from their house. If you have one that's 25 miles from their house, they may be willing to make that drive, and you should not assume that they're not going to. Are they willing to step down into a lesser position? Maybe there's not something available at the same pay level, but they're more than happy to take a lesser position. And if there isn't something that is currently available, talk to them about how to monitor and apply for openings going forward. As Diane said, this is where we get into non-competitive reassignment. This, in essence, a preference. It doesn't mean putting somebody into a job that they're not qualified for. I would certainly argue for my airline clients, if the 787 mechanic, on the state-of-the-art Boeing airliner. I'm not saying you put an inexperienced mechanic in over a more experienced mechanic, but if you've got 2 people that are equally qualified, I think the EEOC at least is going to take the position that the disabled person who's very well qualified should be given that job, or it should be offered to them first.
Yes, correct.
Probably and that's an extreme example. I think more likely just that that if you have several people who are qualified for the position, that and you've got someone who's disabled who's no longer able to perform their job, you should offer them that position before you offer it to somebody else. And that again, this is where you might get pushback from. Maybe you're assigning them to a different store, a different location, a different facility, and the manager I don't want someone who's got an accommodation. Well, that then you're gonna have a discussion with that manager, or that general manager, plant manager, about the legal obligations, and that this person has a legal right to be there. And that this is our organization's policy, and this is what we expect you to work with them like any other employee, right? And if you've gone through those steps, you looked at all the open positions, there's nothing that they're qualified for, there's nothing that they're interested in, or the one position they're interested in, they're not qualified for. At that point, you want to explain to them why. Ideally, again, I would document that. I mean, I've seen too many cases over the years where people assume the worst because people, the employer didn't feel comfortable, didn't want to tell them, well, we didn't give you this job because you're not qualified. It's not always an easy conversation to have. I find that if you actually explain your decision making, that generally goes over better. But if you document that so there's no confusion, I can imagine if you are responding to a charge of discrimination, and your position statement that you submit to Diane's office, if you followed all these steps, I'm pretty confident. Obviously no guarantees, and I know Diane won't make any, but you're going to have a much better outcome if you've done some or all of these things in going through the reassignment process than if you've done none of them. So. All right, so now you've reached the end, whether you've given the accommodation or not, you want to close the loop, meet with the employee, discuss and explain your decision. If you're giving them an accommodation or you're offering them one that's different than what they've asked for, have that, again, you're having the dialogue with them, listen to them. Maybe they can explain, maybe there's another option. Maybe they can explain why that's not the right one. If they say, well, let me talk to my doctor and get back to you, give them that time, right? Provided it's reasonable. Be open-minded and willing to reconsider your position. If you do provide them with an accommodation, like many things, check in from time to time, ask them how they're doing, ask them if they need anything. Same thing, I recommend if you've got an employee who's complaining about harassment, right? Check in with them. How are they doing? Any further problems? And keep a record of that, right? Document that. I spoke to Aaron on this date, asked him how he was doing. He said he was fine, or he asked for this. Keep a record, so you're able to. Because remember, I mean, charges can be filed up to 300 days after the incident, and then the EEOC investigates. They've got a heavy caseload. It could be a year before there's a determination. Then the lawsuit is filed, so it could be years after that you're going to be forced to explain your actions. So why it's always so important to document your decisions. So I know we've been talking a lot, but I want to give the floor to our friend from the EEOC. If you feel free to anything you want to share generally about what we've talked about, any priorities or important recent filings, anything that you want to share, Diane. The floor is yours.
Sure. Well, thank you so much for having me. I appreciate this opportunity. I do enjoy talking about this topic. It is really hard, as we said from the get-go, and you've got to really go lightly and cautiously when you're entering this process. One thing that's not necessarily accommodation related, but is a priority, I should say, for the EEOC, and it's a disability under the ADA, disability related, and that is one of the priorities in the agency is to try to broaden, enlarge, support employment opportunities for people with traditional disabilities. So things like people who are in wheelchairs, people who do not have sight or do not have hearing. And along those lines, the EOC has filed several cases recently about hearing impaired individuals that we just have been seeing a lot of it, that employers seem very, very skeptical that they can do certain jobs like driving trucks, working on a forklift. And in some instances, the reasonable accommodation actually does come up in this context. For example, a case we filed recently in Chicago has to do with a deaf forklift driver. And there were ways in which we would argue he could have been accommodated with some additional lights, for example, motion detectors, things like that. The company said, oh, well, it's too dangerous for you to do this job because you're not going to be able to hear when a truck is nearby or a large piece of equipment, you could get injured. But there were ways we will show in that he claimed that he could have done the job with some of these additional accommodations. And sometimes employers sort of have these sort of very, stringent blanket notions of, no, we can't have a hearing impaired person do this job. We're seeing a lot of that, as I said, and Chicago in particular has filed some cases recently on this issue. So again, it's sort of, thinking outside the box as we talked about, and not making assumptions. And I think that's really, employers need to be flexible in that respect. And not necessarily come into it with, oh no, this person just can't do this because I just know people can't, with that disability, can't do such and such.
Yeah, I think that's great advice. I'm curious from a number of our clients that have hearing impaired employees. What is there kind of a rule of thumb as far as needing to provide either sign language interpreters or some form of interpreting when you have, let's say, pre-shift meetings, the stand-up meetings.
Yeah, right. We do see that. And yes, the company may very well have an accommodation to provide some sort of interpreter services. But see, that's where there are programs and resources and that you as an employer can go to look into that. Like Jan would have those kinds of resources. There are organizations that provide services, often free, for hearing impaired, translation. So, but yes, that may very well be an accommodation that you may need to provide, so they can participate fully in the workforce.
Yeah, and I think your comment about kind of traditional or more common disabilities. I mean, obviously there are a lot of organizations that support and advocate for the hearing impaired, and so there are as opposed to some rare condition that someone may have. There are a lot of organizations that provide either free or discounted interpreting services. I know I've seen
Right.
local governmental agencies that offer that, and so that's one of those things. Before you say no, we can't do it, you should be looking into what might be available to you as an employer, whether they're vocational organizations, etc. The here in Chicago, I think the Lighthouse for the Blind, may a resource. So there are a lot of resources out there, and I think that ties back to my comment earlier about leaving no stone unturned. There's a big difference in my mind if the employer can say, oh, we contacted this, or the National Association for blank disability, and we talked to them, and we talked to the Job Accommodation Network, and we talked to the doctor. We were talking in our prep session about here just north of us in Wisconsin, the University of Wisconsin at Stout has I think a lab that fabricates assistive devices, and they will do that for a consulting fee. And it may not be that expensive at all. And if you bring them involved, get them to do an assessment, and they say, yeah, no, this is not something that can be accommodated. That's a lot different than just, oh, well, we assume this person can't do the job because they have this disability.
Yeah, that's exactly right. And in litigation, EEOC will often hire those kinds of experts, and their testimony is, oh, sure, we could have come up with this, object, this assistive device of some sort, and it would have cost $500 or something. And for the company of that size, that would have been nothing. But people didn't employers, that is, employer representatives, didn't make the effort and weren't proactive to try to look into that or find that out. And of course, ask the employee, especially somebody who's had a disability for a long time and it's a traditional disability. They've been dealing with this for their whole lives, possibly. So they can tell you how they do it and what they need.
Yeah, that's a good point, right? And yeah, and you may say, oh, spending even a couple $1,000s, $1,000 on a consultant or a vocational expert or to fabricate a device. Well, I think I think we at this firm we have very reasonable rates, but it's a lot more expensive to pay a lawyer to defend than it is to, in many cases, to hire someone to help you evaluate the potential for an accommodation. So I think it's a good place to stop. I don't I'll ask both Megan and Diane anything else that either of you all would like to share. If not, we can happy to open it up to questions. I don't see any, but if anyone has questions, please add them. And if not, please reach out to me or to Megan with your questions after, or any CMC attorney with whom you work.
I think one last comment I'll make is just to go into the process with the attitude of what can we do to make this person productive? What can we do to help them do their job? Like, that's the goal. The goal is not to get rid of them and to make your life easier in that respect. And ultimately, your life will become easier if you can find something that helps them do their job. But, the attitude I would suggest having is, what can we do to make them successful? Because it's worth it to us and it will make us successful if we can make our employees successful.
Yeah, I think, right. I mean, I think we all, so many of our clients come to us with, or we talk about how difficult it is to find qualified, capable people. So if you have someone, certainly it's going to be easier and cheaper to keep them than it is to source a new candidate, pay a headhunter, et cetera. It may not always work, but you want to definitely go through that process. We'll give folks another second or two. I'll run through just for everyone. We've obviously got so just a reminder that we've got labor and employment webinar series, a couple more programs this year in November and December. We'll be announcing the next slate of labor and employment webinars, most likely in December. If you have any topics you'd like us to cover, any issues that are pressing for you all, let any of us know, and we will throw that into the hopper and talk about and see if we can't put on a program on that topic. We also have, there's the employer defense report, our blog, putting a lot of good content up there at a pretty regular basis. So check back, and if you're not on our mailing list to get notifications when the blog when articles drop, let us know. We'll get you added. So I will thank Diane for joining us. Really interesting discussion. We really do appreciate you sharing your perspective.
My pleasure. I enjoyed it. I appreciate you inviting me and wanting to hear EOC's perspective. So thank you very much. Thank you to all the participants.
All right. Well, so thanks everybody, for everyone who joined us and stuck with us. I think Megan and I foolishly thought we'd get this done, right around an hour, but I think it was a real interesting discussion. We got, hopefully you all appreciated the input and feedback from Diane, so you can kind of hear how your regulator perceives these issues. Again, this is an issue that Megan and I love to talk about, noodle around. It's kind of a more problem solving than a lot of EEO issues, in terms of, we're not looking at, was this person discriminated against or not. We're actually trying to solve a problem before it turns into a charge or litigation. So don't hesitate to give us or anyone else in the firm that you work with a call if you're challenged with a difficult accommodation question, or if you want you want us to review your accommodation policy, draft an accommodation policy for you, or help you develop a manual or SOP to manage the accommodation process, we've done it all. So thank you. Enjoy the rest of your Thursday, and hopefully you'll join us for the November program. Thank you.